This is an review and answer of the claim of the application of J Supermarket Ltd and Secretary of State to the Mining Department and related appeals.
Yes, good morning, Mr. Malik.
Good morning, my lord, my lady. There are two appeals before the court. In J's Supermarket, I appear for the appellant with Mr. Gaja. Mr. Howarth appears for the Secretary of State. In Prestige Social Care Services, I appear for the appellant with Mr. Gaja and Mr. Jamali. Mr. Howarth appears for the Secretary of State with Mr. Yarrow in that appeal.
Thank you. Well, now, how between you as counsel do you envisage us spending the time? How are you planning to approach it?
Lord, I will conclude my submissions by 1 o'clock.
Well, I wasn't so much. I didn't so much yet have an eye on the clock. It was more. We have two appeals.
Yeah.
Is it the plan that we will hear from you in relation to the first, and then have a response from the Secretary of State, then hear from you in relation to the second, and have a response from the Secretary of State? How does it go?
I see. Lord, the proposal from both of us is that you hear submissions from me first on both appeals to avoid duplication. I will conclude my submissions by 1 o'clock, well before 1 o'clock. You'll then hear submissions from Mr. Howarth on J's Supermarket appeal and the first ground of appeal in Prestige Social Care Services. Mr. Yarrow will make submissions on the second and third grounds of appeal.
Just give us a moment. Thank you. That's fine from our point of view.
I'm grateful.
I mean, we obviously have a fair grasp of the issues that you've raised and argued on paper, and also, of course, a secure knowledge of the judgments under appeal. So you say you've given us an estimate, but we won't hold you to it if you decide to be shorter.
Very grateful.
Yes.
So, my lords, my lady, as the court knows, the two appeals are being heard together because there is common issues as to Annex C1Z of the Secretary of State's policy guidance relating to sponsored licenses and Section 31(2)A of the Senior Courts Act 1981. Annex C1Z requires the Secretary of State to revoke a sponsored license where the business has assigned a certificate of sponsorship for a vacancy that is not genuine. My lords, my lady, J's Supermarket is a small business specializing in South Asian food products. It has 10 employees. It is owned by Mr. Ramachandran. The Secretary of State granted it a sponsor license that enabled it to recruit 2 skilled migrants, Naveen as retail manager and Manoj as a shopkeeper. The Secretary of State decided to revoke that license and upheld that revocation on 12th of November 2024, and that was done by reference to Annex C1Z. In short, the Secretary of State held that the vacancies of Naveen and Manoj were not genuine. The judge below held that there was no public law error in the Secretary of State's conclusion as to Annex C1Z. In the alternative, the judge held that under Section 31(2)A of the Senior Courts Act 1981, it was highly likely that the revocation of the license would have been justified under Annex C1S. And I shall seek to persuade you, my lords, my lady, that contrary to the judge's conclusion, the Secretary of State's decision as to Annex C1Z was unfair and unlawful. That, my lords, my lady, is ground 1. Ground 2 of the appeal is that the judge's approach to Section 31(2)(a) was wrong in law, and he erred in holding that relief could have been declined by reference to Annex C1S. Prestige, on the other hand, is a substantial care provider. It delivers specialist and technical care to patients with high level of needs, including, as the court may have picked from the papers, end-of-life care. The Secretary of State granted it a sponsor license that enabled it to recruit 48 skilled migrants, in addition to 91 individuals who either left the employment or were dismissed, or switched employment or were rejected. The Secretary of State revoked Prestige's license on 15th of October 2024 by reference to Annex C1Z. In short, the Secretary of State held that the vacancy of an employee referred to as Miss K was not a genuine vacancy. The Secretary of State also held that the high staff turnover meant that the business posed a threat to immigration control, and the license ought to be revoked under Annex C2A and B. The judge below held that the Secretary of State's conclusion that Ms. K's role was not genuine under Annex C1Z was unlawful. And that conclusion could not be saved by reference to Section 31(2)(a) or on the grounds of materiality. That conclusion, I shall submit, is correct, but the judge dismissed the judicial review claim on the basis that the Secretary of State was entitled to revoke the license under Annex C2A and B and declined to grant relief under Section 31(2)(a) on that basis. Ground one, my lords and ladies, is that the judge erred in his approach to Section 31(2)(a) in withholding relief despite the conclusion that the Secretary of State's decision as to Annex C1Z was unlawful. Ground two is that the judge erred in his approach to the phrase threat to immigration control. And ground three is that the judge erred as to Annex C2A and B. So subject to any observations, what I propose to do, my lords and ladies, is to first take you to the policy and make submissions as to its content and effect. I will then address you on the law relating to genuine vacancy. Next, I will make submissions on law relating to Section 31(2)(a). Once I've addressed you on law and policy, I will then turn to the facts of the two appeals. We'll take you to key documents and make submissions on the judgments that are under appeal. So I'll start with policy. If you have the authorities bundle, my lords, my lady, the policy is behind tab 12 and tab 13. You have two versions of the policy because the decisions in two appeals were taken at different times. But we have put in the two versions simply to be on the safe side. There is no material difference between the two versions. So what I propose to do, therefore, is to take you to tab 12, the version that version 1024 that took effect on 24th of October 2024. Just taking you straight to the policy part of the policy that concerns genuine vacancy. If you go to page 386, my lords, my lady, you will see a heading genuine vacancy. And the guidance as to the definition of genuine vacancy is set out at paragraphs C144 to C147. Certain examples are given at C146. And my lords and my lady will see 4 bullet points, and you'll see a common theme in all those bullet points. The first example is that the role does not exist. It's all a fiction, fabrication. A business does not require an employee, but sponsors a migrant. Second bullet point, where there is an exaggeration or incorrect job description to deliberately make it appear to meet the requirements of the route. Deliberately is the word I respectfully invite you to bear in mind. Just like the first bullet point, it contemplates a deliberate wrongdoing on part of the business. And you'll see that that example ends with an alternative or is otherwise a shame, where there is a vacancy, but it's a shame vacancy. Third bullet point, just like first 2 bullet points, contemplate a deliberate wrongdoing on part of the business, a job or a role that was created primarily to enable an overseas national to come to and stay in the UK. In other words, if the business decides to sponsor a worker, not because of a commercial reason, but primarily because they wanted that person to come and stay in the UK, that would not be a genuine vacancy. The fourth bullet point, you'll see, refers to the business undertaking a course by which they would tailor to exclude settled workers from being recruited. Tailor to exclude. So they come up with an artificial criteria aimed to exclude settled workers with the sole aim of bringing the overseas national to the United Kingdom. In my respectful submission, the theme is crystal clear. Deliberate wrongdoing is needed to justify a conclusion that a vacancy is not a genuine vacancy under Annex C146. In deciding whether there is or there isn't a genuine vacancy, the decision maker is obliged to make findings as to the sponsor's state of mind. If what has happened is the result of an administrative error or carelessness, that would not meet the definition. There are other provisions in the guidance seeking to address that sort of situation. The guidance will kick in my respective submission only where there is deliberate or dishonest conduct on behalf of the sponsor.
But Mr. Malik, it says these are examples.
These are.
But not limited to the following
Yes.
bullet points. I can see your submission in relation to those bullet
Yes.
points. But does that mean that, in fact, one is limited to a deliberate wrongdoing?
Milady, you're absolutely right that these are examples, but there is, in my submission, a common theme in all these examples. And that common theme, in my respective submission, points to a conclusion that deliberate wrongdoing or dishonesty is needed. That is the first submission that I make. I also submit that word genuine contemplates a vacancy that is genuinely available, in the sense that it's not shame or fabrication or result of a deliberate wrongdoing. So genuine, of course, is complete opposite of forged, fabricated, etc. So these are the two bases on which I make that submission. The submission that I make is supported by the authorities, to which I will take you to. Now, if you go to the next page, my lords, my lady, page 387, you'll see a heading, behavior that is not conducive to the public good. You'll see that the Secretary of State says that the Home Office will not issue licenses whose actions and behaviors are not conducive to the public good. There is an obvious reason for that, and you'll see certain examples. If a business is dishonest, then then it would not be conducive to the public good for that business to retain a license. If the Secretary of State takes the view that a business has previously created non-genuine vacancies, has been dishonest, then in all likelihood the Secretary of State will not issue license to that business on a fresh application. Will not license organizations is the phrase that is used at C149. So it's not simply about revocation of licenses, it's also about issuing new licenses. And then if you read that with the next paragraph, 1.50, the Home Office will refuse a sponsor license application if a prospective or existing sponsor is engaging or has ever engaged in such behavior or actions. If the Secretary of State has rationally found that a business is dishonest, they created false vacancies, they revoke the license, the business then makes a new application, in all likelihood, for good reason, the Secretary of State will refuse to license.
You're drawing a connection between genuine vacancy and not conducive.
So that
I'm not seeing on a high-level look at this document why there should be some connection. But the genuine vacancy
yes
comes under the title of complying with immigration laws.
Yes.
There's then an intervening heading to do with complying with wider UK law, and there's then behaviour not conducive. It may not matter to your argument at all,
no.
But it rather looks at behaviour not conducive to the public good is concerned with other types of
Yes.
unattractive behaviour, not particularly to do with genuineness of the vacancies and the upholding of immigration.
Lord, the reason I felt that I should take you to this part of the guidance is because of an argument that I will make in due course. If the Secretary of State revokes the license on the basis that there is no genuine vacancy, and if you accept my submission that that finding entails a finding of dishonesty or deliberate wrongdoing, the license is gone. The employer then makes a new application to the Secretary of State, a new application for a sponsor license. What will happen to that application? The submission that I make is that the Secretary of State in all likelihood, will refuse any new application on the basis that there was previous dishonesty or deliberate
So
wrongdoing.
you're taking us to this to show us how, in your view, the system is likely to work.
Yes.
Not in order to say that the construction of one part of the
Absolutely.
guidance is
Absolutely.
helped by the other part.
You're worried you're
Absolutely.
not going to get a license in the future.
Yeah.
That's the point, exactly.
Can I just, I can see why you bring it to our attention. Can I just ask, has this all changed or not?
No.
So this is still the current structure?
Yes.
Yeah.
Yes.
Thank you.
And there is a perfect sense in this scheme. If a business is dishonest, then why would the Secretary of State issue a license to that business? But the position would be different. Of course, I'll develop that point in due course if there is merely an administrative error by a business and license is revoked not on the basis of a finding that there is deliberate wrongdoing, but there was an administrative error or carelessness, then the possibility of getting a new license would be a real possibility.
Yeah.
Now, if you then, my lords, milady, go to page 405. You'll see a heading, outcome of compliance checks. And under that heading, you'll see a paragraph, paragraph 7.26. It says, where there is a more serious breach, indicating, and it's the third bullet point that is relevant, you pose a serious threat to immigration control. That appears on the next page, page 406. If that happens, the Secretary of State may decide either to suspend the license or revoke your license without prior suspension. So one of the matters that you will consider concerns proper construction of the phrase a serious threat to immigration control. A threat, in my submission, is a strong word. It is different from a risk. So it, in my submission, poses a high threshold. Now that threshold, in my submission, is elevated further by the addition of the word serious. So not every threat to immigration control would bring a business within this provision. That threat has to be a serious threat. And that threat must be directed to immigration control, in my respectful submission, in a broader sense. There will always be a risk that when a sponsor employs an overseas migrant, there's always a risk that once the migrant is in this country, that migrant may do something that is not in accordance with the law. Migrant may commit a criminal offense, the migrant may breach an immigration condition. Sensibly construed, the policy cannot contemplate an outcome whereby a license is revoked simply on the basis that there is a real risk or a serious risk that sponsoring a worker would lead to a breach of immigration control in that case. You'll see that a breach of immigration control are not the words that appear. Threat to immigration control. It's a strong word, high threshold in my submission. Now, if I then take you to page 408 of the bundle.
Sorry to interrupt. Before we leave this, you construe serious threat by reference to the other bullet points in terms of giving it light or colour?
I'm grateful. Yes, my lord. Yes, there is, my lord. You'll see a sort of common theme in all 4 bullet points. They all contemplate something that is serious, a broader, in a broader way, and that is also reinforced by the way in which that paragraph starts at the end of page 405, where there is a more serious breach. So not every breach would bring a business within the ambit of this provision, but a breach that is more serious.
More serious than relatively minor.
My submission would be more serious than other breaches referred to in this guidance.
Well, it looks, I'd say it looks to me as if 25 and 26 are cheek by jowl with each other. One is a system for relatively minor curable breaches, and the other for more serious breaches. But there we are. It's there to be read. And this is guidance.
This is indeed guidance, yes. Yes. But the point that I need to make for the purposes of my ground is really emphasize on the word serious and threat as it appears in the 3rd bullet point, a serious threat. Now, how the Secretary of State goes about making a decision. Now, if you go to page 408 of the bundle,
I'm sorry, before we do that again, and following on from what my Lord Justice Peter Jackson has said, if one looks at C724, it says where there's been a breach or suspected breach of your sponsorship duties, or if we consider you pose a threat to immigration control, etc., then we'll decide on the most appropriate course of action. Then you've got 25, which is relatively minor, and then you've got 26, which is more serious. So I think at least those paragraphs need to be read together.
I'm very grateful, yes. So, my lady, I'm very grateful. So, just looking at paragraph 7.24, you'll see that the words "a threat to immigration control" appear. But C 7.26 uses the word "a serious threat to immigration control." So, if there is merely a threat to immigration control, then it's C.24. If there is something more than a threat, if it is a serious threat, then it's C 7.26. But prestige is all about 7.26. So how the Secretary of State goes about making a decision, if you go to page 412, you'll see a heading suspending your license.
Sorry, which page?
Page 412.
Thank you very much.
So if the Secretary of State suspects that there is a possible breach, the Secretary of State will investigate. And if you look at the heading, how we decide to suspend your license, paragraph C9.7, the policy is that if any of the circumstances in Annex C1 arise, then the Secretary of State will revoke the license immediately or suspend it. And compare that, my lords, my lady, with the next paragraph. If any of the circumstances in Annex C2 or C3 arise, then we will first consider downgrading your license. So the obligation under the policy is that if there are no C1 circumstances, but if C2 circumstances arise, the starting point, what should be considered first, is downgrading the license. And I'll take you to Annex C1 and C2 to explain the difference. In short, C1 sets out circumstances that are serious. C2 sets out the circumstances that are not as serious as C1. The point is that C1 leads to mandatory immediate revocation or suspension, whereas C2 means first consider downgrading the license, But then the Secretary of State is entitled, of course, to suspend or revoke the license if the minor breach, which is not as serious as C1, is sustained non-compliance over a period of time, or where there have been a number of minor breaches indicate a serious systematic failing.
Are you going to explain the grading system for licenses?
Yes, that will appear on the next page. You'll then see a heading, the process we follow. So the Secretary of State, if the Secretary of State takes the view that there is something wrong, the Secretary of State writes to the business, suspends the license, writes to the business. Look at the next page, 413, 9.10. The Secretary of State will write with initial reasons for suspension and telling the business that an investigation is taking place. 9.11, the Secretary of State will give 20 working days to the business to address the concerns. That is essentially to comply with the common law duty of fairness. This is your opportunity, the policy says, to seek a review of our decision or set out mitigating arguments that you believe exist. Your response must be in writing and supported by relevant evidence. So that is the opportunity for the business to say to the Secretary of State that there is no breach, or if there is a breach, there is mitigation available, and therefore license should not be revoked. If the Secretary of State identifies further reasons during the course of the investigation, then 9.12, the Secretary of State will write to the business again to comply with the common law duty of fairness, bring the additional reasons to their attention, and give them another 20 days to respond. Once the Secretary of State receives the response, the Secretary of State will then take the appropriate action. And just to answer the question, my Lord, that you raised, my Lord Peter Jackson, if you look at paragraph 9.15.
Yes, it was more to just have a pen picture of what A licenses are. There are then premium A licenses and B licenses and so forth. What does that mean in terms of the rights conferred?
Well, a license with A rating, just put it as succinctly as possible, enjoys certain entitlements, benefits that are not open to a license and B rating. If someone is on B rating, then the Secretary of State will, in due course, revoke that license completely, unless within a specific period of time, the business complies with an action plan that the Secretary of State gives that business and is promoted to A rating.
But so the norm is an A rating.
Yes. Yes. And downgrading is B rating. But when you are at level B, then you are issued with an action plan. The Secretary of State says that, well, you have 3 months or 6 months to put your house in order. I require you to take these actions. If you don't take these actions within 3 months, 6 months, then I will revoke.
So what did your respective clients hold as licenses in these cases?
Well, they all were A rated sponsors. But the point of showing, my Lord, you paragraph 9.15 is that the Secretary of State has a range of sanctions available to her. And revocation is the most draconian sanction. The Secretary of State can downgrade, reinstate the license, reinstate to B rating, issue an action plan. Or prevent the business from assigning new certificates, prevent the business from using unassigned certificates, or revoke the license. So if, for example, the Secretary of State takes the view that a business is just recruiting too many migrants. But there is no concern as to genuine vacancy or deliberate wrongdoing. The Secretary of State takes the view that the business is recruiting just too many migrants. The Secretary of State can prevent them from assigning new certificates, essentially to recruit any further individuals.
Can I just ask, the certificate of sponsorships, they're directed to both people outside the jurisdiction,
Yes.
who then get leave to enter because they've got a certificate of sponsor, and perhaps those within the jurisdiction who've already got leave but are about to lose their leave, etc.
Exactly.
Yeah.
So a business applies to the Secretary of State for allocation of a certificate of sponsorship, essentially to recruit a migrant either from abroad or from within the UK, a person who's subject to immigration control.
Who may have limited leave to remain and needs the next step, as it were.
Precisely. But it is perhaps appropriate to emphasize that a business can only recruit a migrant and assign a certificate of sponsorship if their role appears on what was called a shortage occupation list or appendix skilled worker in the immigration rules now. So these are the roles that the government considers are short in supply in the domestic labor market. So not every person can be sponsored, but only those who businesses actually need, where enough local workforce is not available. How is it that the suspension affects the license? It sets out the next page, page 414. Essentially, it's status quo. A business is not allowed to issue new certificates while the license is suspended.
And downgrading licenses to B rating is dealt with on page 408, paragraphs beginning at C8.
Yes, earlier in the policy, yes. And if you, Milady, if you wish to see a sort of summary of what happens, then see page 414 under the heading, what happens if you reinstate your license?
Thank you.
Then page 415, the policy about revoking your license. And under that heading, if you consider the heading, how we decide whether to revoke your license, C10.4 says that C1, Annex C1 sets out the circumstances in which we will revoke your license. These are mandatory grounds. C2 is not mandatory, but the position is that the Secretary of State will normally revoke the license unless there are exceptional circumstances. If you read that with the earlier paragraphs, the effect is the same, that if a breach isn't serious enough, if it's a one-off breach, then a revocation may not be appropriate. But if there is a minor breach, but the non-compliance is over a sustained period of time, or a number of minor breaches, then that may justify revocation of the license. Then page 417, this concerns reapplying for license if it has been revoked. You'll see from 10.16 that if a license is revoked, then it's not possible for the business to apply for a new license within 12 months, subject to the Secretary of State's residual discretion. In exceptional circumstances, she may allow a business to make an application within that period of time. But if you look at paragraph C 10.18, you'll see that whenever a business makes a new application, the earlier revocation would be a starting point, in the sense that they would need to demonstrate that they have addressed any reasons why your previous license was revoked. If there was an administrative error, a systemic problem, if the evidence is that that has been fixed, good. But if there is dishonesty or deliberate wrongdoing, then in all likelihood, that isn't a matter that can be addressed or can be addressed lightly. Can I then show you NX C1 and C2? So NX C1 appears at page 419. Circumstances in which we will revoke your license. Now, the power to revoke the license only arises if these circumstances actually arise. The decision maker has to make a finding that these circumstances arise, a suspicion that these circumstances may arise is not enough. So the decision maker must make a finding that one of these conditions are engaged. The relevant condition is at page 423, condition Z, right at the end of that page. We have reasonable grounds to believe that the role for which you have assigned a COS is not genuine. The word genuine is used. And then examples are given that are essentially copied from the earlier part of the policy that I've taken you to. Apart from the fact that we don't, for some reason, have the fourth bullet point, but it matters not. Again, you'll see a common theme in our examples, and you'll see that the word genuine appears.
Can I just ask you about your earlier submission that you have to make a finding?
Yes.
Obviously, you do have to make a finding about what is set out in Z. But Z is a finding that we have reasonable grounds. It's
yes.
not that it did happen.
Yes.
How does that work?
Yes, so a finding must be that there are reasonable grounds to believe that there is no genuine vacancy. Lord, I'm not sure with respect if it matters much. If the Secretary of State is entitled to conclude that the vacancy isn't genuine, then by default, that means that there are reasonable grounds to believe that the vacancy is not genuine.
I don't think that works. I mean, compare A, which is a couple of pages back, which is circumstances we find, etc. Whereas Z is a reasonable grounds to believe. And we're very familiar, obviously, with the difference between those two situations. So there may be something in it.
Okay. So I mean, it matters not to the argument that I make. So I'm content for the court to proceed on the basis that there is this difference, and the question for the decision maker is whether there are reasonable grounds to believe that a vacancy is not genuine. Genuine means a vacancy that is fabricated, where there's deliberate wrongdoing.
But in libel proceedings, people spend a great deal of time and money trying to persuade a court that this has the meaning that you must find it, or only that you've got reasonable grounds to find it. And
Yes.
So that there obviously is a difference
There
in
is.
meaning between the two.
Yes. But perhaps that is for a different appeal. There isn't. But I mean, it matters not in my submission in this appeal. Because this appeal is really about what is meant by genuine, what is meant by the examples that are given.
I was just looking at the very long list going down to double O.
Yes.
Actually, Z is the only reasonable grounds one that jumps out at me.
Yes,
The rest are all just bald facts.
Yes.
But there it is.
Yes. So this is Z. Now the other provision that you will look at is one that appears at page 422, condition S. The role undertaken by the worker you have sponsored does not match one or both of the following: the occupation code stated on the COS and the job description on the COS. And match, as the case law will show, does not necessarily mean an exact match. There isn't a sort of mathematical assessment that the decision maker has to make. The broad point is that if, for example, a business recruits a chef, and instead of cooking in the kitchen, the chef spends all his time cleaning, then there would be a mismatch between the job description and the actual role. Now that can happen even where there is no deliberate wrongdoing on part of the business. It could be a case where the vacancy was genuine when the migrant was recruited, but then in due course the business takes the view that, well, he isn't a good chef, and better to put him on cleaning and so on and so forth.
So which bit are you reading on?
My Lord, S at page 422. So this is the point that the judge made in Jay's Supermarket. Essentially, the judge said that, well, if not C1Z, then C1S would apply. So this is NX C1. There are a number of other conditions that are not relevant. NX C2 is at page 426.
406.
Sorry, 426.
Yeah.
426. Now, you will see that this sets out the circumstances in which the Secretary of State will normally revoke the license. We may downgrade or suspend your license first. If you read that with the earlier part of the guidance that I've shown you, that the scheme is clear, that the starting point would be downgrading of the license if NX2 circumstances arise. And my lords will see that these are the circumstances that are not as serious as NX-C1 circumstances. But two conditions are relevant to our appeals, condition A and condition B. A is where there is a failure to comply with the sponsor duties in section C1, which includes the bit about posing a serious threat to immigration control. And B is where the Secretary of State is not satisfied that the business is using a process or procedure necessary to fully comply with your sponsor duties. So an occasional glitch is not enough. The attention has to be on the process and procedure that the business has in place.
So the difference in the descriptions in the headings of the annex is will revoke and will normally revoke.
Yes, indeed. And the policies that the effect of will normally revoke is that when those circumstances arise, the decision maker will first consider downgrading. And if downgrading isn't considered appropriate, will then consider whether to revoke.
Sorry, I lost the thread with that. The basis for saying that we start with downgrading and then consider revocation is what?
Yeah. So this is paragraph C9.8. Sorry.
That's under the suspension.
Yes. So C9.8. Yes. So if any of the circumstances listed in Annex C2 or C3 arise, we will first consider downgrading your license.
Right.
So the reason why I'm just at pains to emphasize this, perhaps it isn't even an issue between the parties. In Jay's Supermarket, there was Annex C1Z ground, and there were a number of Annex C2 grounds. There is no appeal before you in relation to Annex C2 grounds. The appeal before you concerns only Annex C1 ground. The judge essentially held that if it was only Annex C2 grounds, then the judge would not have decided to withhold relief under Section 31(2)A, because it wasn't clear that the outcome would not be same, or it's highly likely that the outcome would not be substantially different. So it matters not. If I'm right about an XC1, the appeal succeeds. If I'm not, then the appeal fails. Now, so this is the policy. If I may address you then to the law as to genuine vacancy and the common law obligations of the
Before we
Secretary of
leave the
State.
policy,
Yes.
just want to know whether anything is to be gleaned from the first guiding principle at C1.3, which is at 445,
Yes.
which is the statement that sponsorship is a privilege, not a right.
Yes.
Does that lend colour to the process that is taking place here?
There's no dispute, my lord. Sponsorship is a privilege. It's not a right. Those who benefit must play their role. There is a room for abuse. There are businesses, there are employers looking to cheat the system. Nothing in my submission would downplay the obligation of the sponsor.
But I mean, there are clearly instances where decisions are being made in respect to matters that are rights within the immigration field. Here we have decisions being made about something that is described as being a privilege.
I see, yes.
I appreciate that the grant or the loss of a COS regime is of extreme importance to an organisation and to its employees and to its customers. But nevertheless, does that not lend some colour to the level of scrutiny that ought to be applied to decision making in this field?
Yes. So the Secretary of State has published a policy as to the circumstances in which that privilege would be withheld. The Secretary of State is obliged to comply with the policy. There is a public law obligation. In a judicial review claim, it would be for the court to decide whether there was or wasn't compliance with the policy. If the Secretary of State hasn't complied with the policy, the decision would be an unlawful decision. And in my submission, it matters not that the sponsorship is a privilege, not a right, simply because an individual under public law has a right to be considered under whatever policy the executive deems to promulgate. The right is to be dealt with in accordance with this policy. And that really is the answer. Now, if I may then address you as to the common law obligations relating to a finding of genuine vacancy. There are a number of different authorities, but in my submission, this court needs only to look at three authorities that are binding. So I'll take you to those authorities as opposed to the first instance judgments. The first is the judgment of the Supreme Court in Bank Malat. Lords, lady, are familiar with the judgment. It's behind tab 3 of the bundle. And the paragraph that is relevant is paragraph 179. Which you have at page 185 of the bundle. So this is where Lord Neuberger essentially summarizes where common law has reached in relation to the obligation to act fairly. There is an extensive discussion earlier in the judgment as to various authorities. The conclusion is at paragraph 179. There is now, Lord Neuberger says, a rule, a public law rule, that before a statutory power is exercised, that would be the power to revoke the license, any person who foreseeably would be significantly detrimentally affected by the exercise, that is the business, should be given the opportunity to make representations in advance. There are two exceptions, but those exceptions do not apply. So these businesses have a common law right to be given an opportunity to make submissions in advance. Now, how that applies in immigration context is considered by this court in a case called Balaji Gari. Balaji Gari is...
Can I, before you leave that, can I
Yes.
just ask you this? So are you suggesting, because a strict reading of paragraph 179 would be before you even send the letter saying we're going to revoke your license, you have to say,
Yes.
we're now thinking of sending you a letter saying we're going to revoke your license, which would mean that the Secretary of State's policy was wrong from the start.
No, so the Secretary of State's policy is that when the Secretary of State has concerns,
Yeah.
she will not revoke the license unless there are sort of exceptional circumstances. Instead of revoking the license, she will suspend the license and give reasons to the business as to why she is thinking to revoke the license.
But if you read what Lord Neuberger says, literally, says before you act significantly detrimentally to any business, you've got to have the opportunity to make representations in advance. And even a suspension
Yes.
is exercising statutory power.
Absolutely.
But you don't press it to that extent.
Not in this case. Of course, there is an authority that makes it crystal clear that this applies also to suspension stage. So before the Secretary of State even suspends the license, the obligation is to ask the business to make submissions. But in reality, in almost all these cases, there is no judicial review challenge of the suspension decision. Because instead of sort of challenging the suspension decision, it's far more efficient, pragmatic for the business to make representations to the Secretary of State and then challenge it.
All I'm asking is whether, in fact, you're putting too much weight on what Lord Neuberger says before any exercise of statutory power, because if right, that would mean that you couldn't even suspend without having written. And I know there is an authority to that effect. I just wonder whether that's right.
So, my Lord, whether, again, the submission that I make with respect is whether that authority is right. Say this to the Secretary is again perhaps a matter to be dealt with in a different
Right,
appeal.
fine, okay.
Sorry
to
because I accept. I mean, in this case, there is no challenge to the suspension decision. The argument that I make is that there was a right to be given the opportunity to make submissions before the revocation decision.
Yes. But I mean, you'd have to unpick this because, for example, the Secretary of State's representative didn't turn up in Tooting just to shop. It was there it was an appointment in order to run a rule over what was going on in the business, and an opportunity was given on that occasion for people to explain themselves about what was happening. So it's an iterative process. I mean, what this would, for example, prevent, what is said at 179, is simply, without more, a letter coming from Whitehall saying your licence is revoked, without there having been any preliminary investigation known to the shop holder.
There is a little more to that, which will become clear when you look at the next authority, because in Balaji Gari, the court actually picked this paragraph and explained what actually...
Let's go to Balaji Gari now. Thank you.
Balaji Gari, behind tab 2 of the bundle, migrants were refused indefinite leave to remain on the grounds of dishonesty, reprehensible conduct. There was a discrepancy in the earnings that they declared to HMRC and the earnings that they provided to the Secretary of State in their applications. The Secretary of State made the decision without giving prior notice or opportunity, save as to one appeal where there was that opportunity in the form of an interview, but the court took the view that that wasn't enough, and that may answer the point that, Lord, you had in mind. So if you go to page 23 of the bundle, And I will take you to these paragraphs in a chronological order to avoid duplication. But the point about fairness will come in due course. So paragraph 42, a discrepancy may justifiably give rise to a suspicion that it is the result of dishonesty, but it does not by itself justify a conclusion to that effect, just under letter H. So in this context, when the Secretary of State takes the view that there is a discrepancy between the job description in the certificate and the role that an applicant is performing, an employee is performing, that may give rise to a suspicion, but not without more a finding of dishonesty. Look at the next paragraph, next page, page 24. This is important in this context. It concerns the burden and standard of proof. Even in the judicial review context, the burden of proof rests on the Secretary of State to demonstrate that there is dishonesty or reprehensible conduct. The Secretary of State argued that the concept of burden and standard of proof does not apply in judicial review context because the court isn't conducting a fact-finding exercise. But you will see that that argument was rejected. The Secretary of State must be satisfied that dishonesty has occurred. The standard of proof being balance of probabilities, bearing in mind the serious nature of the allegation and the serious consequences which follow from such a finding. So burden of proof is on the Secretary of State. It is not for a person to prove that he is not dishonest, and the decision maker must bear in mind the serious nature of the allegation and consequences from that finding. And this applies with full force in this context, in the sponsor license context. This court has said so in the final authority that I'll take you to. But you'll then see a heading just above paragraph 45, the requirements of procedural fairness. And under that heading, the court considers a number of different authorities. At some point, I think it's paragraph 59, Bank Malat is considered as well. So is paragraph 179 of Bank Malat. But the conclusion is at paragraph 55. And this really is the test as to what the Bank Malat principle actually entails. We have come to the conclusion that where the Secretary of State is minded to refuse ILR, here minded to revoke the license on the basis of dishonesty or other reprehensible conduct, he is required, as a matter of procedural fairness, to indicate clearly to the applicant that he has that suspicion, to give the applicant an opportunity to respond.
I'm sorry, I was lost there. Could you tell me where you've just read from?
So paragraph 55.
Thank you.
Just under letter D. So this really is the test.
I have it.
This is the test that in my submission this court ought to apply. Whether there was a clear indication before revocation that the business is suspected of dishonesty or reprehensible conduct. If there is an indication that isn't clear enough, then that is not enough. A clear indication. Now, there were 4 appeals before the court. In one of the 4 cases, before the Secretary of State took the decision, an appellant was interviewed. The discrepancy was identified in that interview, and it was put to the applicant, and he was asked for an explanation. He provided an explanation, and the Secretary of State rejected it. On appeal, the Secretary of State argued that, well, irrespective of what happened with other cases, surely in that case there was compliance with the common law duty of fairness, because the discrepancy was identified and the applicant was given an opportunity to respond. The court disagreed. the court said that that wasn't an opportunity that met the clear indication criteria.
Well, everything will depend on the facts. I mean, if you're dragged off the streets and interviewed with no notice at all about a serious allegation,
Yes.
that may not be. If you are set up as an interview, we're going to talk about your immigration status
Absolutely.
and put some really difficult issues to you, that might be. So I'm not sure we derive very much from analysing different cases.
No.
I can see it's quite a fun case to point to, but does it help us in the law?
It is. So yes, my lord, you need not to look at the facts of that case, my lord. You're absolutely right. It entirely depends on what happened on the day, but the submission really, and I don't need the authority, I don't need to tell you the facts to make that submission, is that you must put the allegation to the person. You must say to the person that I suspect that you're dishonest. I mean, whether it's in an interview or in a letter, but you must put that to the
Is it good enough to
business.
say, I suspect that this job is not genuine?
That would, yes.
That would do.
That would do, yes. And in my submission, that is what common law requires. If the Secretary of State starts interview without telling the person why they are being interviewed, there is no clear indication or even indication that there is a suspicion.
Yes, you have to share your suspicion.
You have to share your suspicion, exactly.
Yes,
That's it.
yes, exactly. There's no magic form of words.
No.
You have to share your suspicion.
Yes, and
It's the way you do it will depend upon the way you do it, and it will have to be then decided whether you've shared it.
yes. So clear indication test that the court identified at paragraph 55 in my submission is identified, so bearing in mind this particular context. The point essentially is that the Secretary of State ought to do everything so that it's clear to the person as to what they're being suspected of, so that they could address the concern.
Right, and so that's, in practical terms, that's what the judge had to consider in each of these cases, as to whether the respondent knew what the Secretary of State was concerned about.
Yes. Yes. So this is Balajigari, but yes. So in short, just to conclude, an interview or a letter is not enough unless
May not be enough.
may not be enough. But it depends on the content of the interview or content of the letter. The final authority on the subject is Presswick, where Balajigari was considered and applied in sponsor license context. Presswick is tab 8 of the bundle. A sponsor license case, if I may, where a license is revoked on the basis that a vacancy was not a genuine vacancy. Now, if you look at paragraph 4 of the judgment, page 267, you see a point that Lord Justice Baker made about the purpose of this scheme. So allowing skilled migrants to come to this country and to work is not an act of grace as such. The scheme is to protect, enhance national economy. The scheme plays an important role in national economy. There were over 100,000 sponsors in the UK, around 9,000 in social care sector alone. If you then go to page 283 of the bundle, you'll see a heading, the SCL case background. And this is the case where the license was revoked on the grounds that there wasn't a genuine vacancy. So if you look at paragraph 59, you'll see that Lord Justice Baker quoted from the certificate of sponsorship. And this is the exercise that, in my submission, that the court would do in this case to decide whether there wasn't or was unlawful conduct. So job description is set out. Then the Secretary of State's compliance team, just like this case, conducted a compliance visit. They interviewed the managing director, Mr. Tahir, and an employee called Ms. Rima. And after the interview, they sent a letter to the business, not revoking the license, but telling them what their concerns were. So this is at paragraph 61. The letter said that we are not satisfied that the role of a senior care worker undertaken by Ms. Rima represents genuine vacancies within your organization. The Secretary of State, before making the decision, tells the business that we do not consider that this is a genuine vacancy. And then refers to NX C1S and Z. Here, Secretary of State refers to Z, not S, but in that case, both were referred to. And then if you look at paragraph 62, that letter said that, well, this is your opportunity to explain the above issues before we begin revocation action. We have suspended your license. So they knew what the concern was. And the Secretary of State was saying, well, I'm giving you the opportunity to address my concern. And that concern was then addressed. See paragraph 63. Ms. Rima provided a statement explaining her role and saying that the vacancy is genuine. Paragraph 64, the Secretary of State considers that response and revokes the license.
It would help me to know what assistance we get from going through the facts of the other case. What's the point that you're leading up to?
Well, essentially responding to the points that Miller and Friends would make. Miller and Friends would say that in this case, in Jay's Supermarket in Prestige, letters were sent to the applicants telling them what the Secretary of State's concerns were. And those letters were the opportunity for the applicant, for the businesses to provide explanation, to put forward their response. So the court needs to look at that case and look at the facts of that case to decide whether to accept or reject that submission. The court in Prestwick rejected that submission and said that those letters were not enough, despite the fact that they said that the vacancy was not genuine and gave the opportunity to make submissions.
Well, is that right? Because if you look at 69, what happened was the Secretary of State lost in SCL at the first round, and then was the appellant. And the judicial review claim was allowed on one ground, that the Secretary of State had failed to conduct an adequately reasoned global assessment of all relevant considerations in deciding it. It wasn't a valid due diligence. No, that isn't what happened, my Lord. So, I mean, of course, I represented SCL in that case. So, the judicial review claim was successful on that ground, my Lord. The ground that there was a failure to conduct a global assessment. The judge dismissed the other grounds, the Balajigari grounds and rationality grounds. The Secretary of State appealed on that ground to the Court of Appeal. And SCL put in a respondent's notice saying that the judge was wrong to dismiss the Balajigari and other grounds. The Court of Appeal agreed. The Court of Appeal, this court said that the judge was wrong to dismiss Balajigari grounds and upheld the judge's order on those additional grounds, quashed the decision on that basis. And where do they deal with that?
Yes, my Lord, well, that of course is at the heart of my case. So, my Lord, I'm very happy take
No,
you.
well, you carry on. Yeah.
So it's just that if I take you through these paragraphs in a sort of sequential order,
Yeah.
that would make sense. That would more, that perhaps would be easier to understand the argument. So and then paragraph 64 and 65, you'll see that the license is revoked, and it's revoked on the basis that there is a discrepancy, and the vacancy is not a genuine vacancy. The Secretary of State deals with the evidence, deals with the witness statement, and concludes that the vacancy is not genuine. Now, if you perhaps just look at the text that appears just above paragraph 66, the Secretary of State said that, well, there isn't a genuine vacancy, and you have exaggerated the role in order to facilitate Ms. Rima's stay, and relied on NX C1S and Z. And the Secretary of State said, just like this case, that downgrading of the license is not appropriate because of the breach. Then, my Lord, as I said, the judicial review claim failed on rationality, fairness grounds, but was successful on the global assessment ground, which isn't an issue before the court. Now, if I may, then just to address the point, my Lord, that my Lord, the Senior President made as to where they dealt with those arguments. So if you go to page 299 of the bundle,
Yeah.
the court agreed with the Secretary of State on the global assessment ground.
Yeah.
Paragraph 117, SCL invites the court to uphold the judge's decision on these three grounds. And these are the grounds that I pursue before you. The Secretary of State acted in a procedurally unfair manner. The Secretary of State failed to ask a self-correct question that, well, a dishonesty is needed. There was misconstruction of the guidance, reasons were inadequate, etc. Now, under that heading, the court then, if you see paragraph 118, the submission was that the interviews were not conducted in accordance with common law duty of fairness. There was non-compliance with Bank Malat Balaji Gari. The allegation was not put to Mr. Tahir and Ms. Rima for comment. Specific questions were not asked. No fair opportunity was given to respond to potentially adverse matters. Look at the next paragraph, page 301, page 112. The Secretary of State reversed the burden of proof, essentially expected the business to establish that the vacancy was a genuine vacancy, and wrongly, paragraph 124, wrongly proceeded on the basis that the individuals, if a person is not performing every single task, then the vacancy would not be a genuine vacancy. The Secretary of State made the argument that, in my submission, Miller and Friends make in this case. See paragraph 125. You'll hear from Miller and Friends in due course. These are the arguments that they make, that it's a light trigger, high degree of trust. There were suspension, letters were sent, and an opportunity was given, and that complied with the duty of fairness. Discussion, page 303. So earlier in the judgment, the court considers various authorities, Bank Malat, etc. Paragraph 132, the court adopts Bank Malat and Balaji Gari in this context, and then identifies four principles. And these are the four principles that, by reference to which, in my submission, the court ought to adjudicate this appeal. The first principle, paragraph 133, dishonesty is a serious allegation carrying with it serious consequences. It is for the Secretary of State to establish on balance of probabilities that the sponsor acted dishonestly. There is no burden on the sponsor to prove that it did not. The burden of proof rests on the Secretary of State. Second principle, paragraph 134, where the Secretary of State has a suspicion, where there is a suspicion, she must indicate clearly to the sponsor that she has that suspicion, so that the sponsor has a fair opportunity to respond. Third, before the Secretary of State makes a decision, she must consider the alternatives. Well, is there another explanation for what has happened? Could it be carelessness or an administrative error? Or is there dishonesty? And then 136, the Secretary of State ought to give reasons. There are two paragraphs that I invite the court to read in full in due course. So paragraph 137 and 138. Those were the reasons why that appeal succeeded.
But isn't that just the factual circumstances of that case, that in that particular case, the Secretary of State had failed to set out with clarity that they were saying it wasn't a genuine example?
Yeah.
And that, I mean, I'm very happy with the principles. It's just when you try and read across facts.
Facts, no.
And also, just so that you can deal fairly with it, and perhaps the others can, it's perfectly apparent that there seems to be a developing a wholesale industry of cross-referring facts from cases to others. If you look at some of the length of the judgments that we're being confronted with now, that's not really what we're looking at authorities for. We're looking for them for the principles, not in this factual situation.
I completely agree, my lord. But you do get 4 principles of law from those paragraphs.
That I've got.
Yeah. So if you
but those aren't the ones, bizarrely, that have been marked. It's the factual ones that have been marked, and that might mislead the careless reader into reading the wrong bit of the authority.
my lord, you are right. I think I ought to take responsibility. Yes. So in my skeleton, of course, I referred to paragraphs 134 to 136. Yeah. But may I just identify two points that arise from 137. First, if you look just against letter D, I accept the submission that at no stage prior to the revocation decision did the Secretary of State expressly allege dishonesty. So an express allegation of dishonesty or deliberate wrongdoing is needed to comply with the clear indication principle. So you've got to tell the person that I suspect you of dishonesty.
That's not the principle that is articulated at 134.
So 134 is...
She must indicate clearly to the sponsor she has the suspicions.
Yeah. So a clear indication, in my submission, the court said...
Yes, I mean, clearly, I mean, we aren't and couldn't take issue with the acceptance of your submission that there was no express allegation of dishonesty or deliberate wrongdoing made in that case. But we can't transmogrify that into the invariable standard that must be met in every case. Well, on the basis of this authority.
Okay, so this court has held that the standard is clear indication. And that is the standard by reference to which, in my submission, the court must adjudicate these two cases. Yes. The submission that I make is that standard requires there to be an express allegation of dishonesty. I do make that submission. That unless you tell the person that I think that you are being dishonest, that person, in my submission, will not get a fair opportunity to respond to the allegation. How is it that that person would know what the Secretary of State has in mind?
If it's drawn, that's paragraph 136, fourth. If the Secretary of State draws the inference of dishonesty, she must set out the reasons. Yeah. And that's really your point, isn't it? No more nor less.
That is the point, yes.
Yeah.
Yes. Yes. So express allegation, I'll leave it there. And then perhaps just at the end of that paragraph, a discrepancy alone is not enough. So there ought not to be a sort of logical gap. So if there is a mismatch, that may be the result of an administrative error, carelessness, recklessness. That does not necessarily mean dishonesty. You must apply your mind in my submission to whether there wasn't dishonesty.
Mr. Mack, I'm not sure that I've quite followed what you're saying about dishonesty, because you've just been taken to 136,
Yeah.
which is if the Secretary of State draws the inference of dishonesty, she must set out her reasons in the revocation letter. But that's further along the process.
That's further on, yes.
You are, in fact, and you said yes to that, but I just want to be clear in my head, because you say the duty on the Secretary of State arises much earlier in the process, and that's at 134. I have suspicions that you are dishonest.
Yes.
And it indicate that clearly in order that there's a fair opportunity further up the process. So it's 134 rather than 136 that you're relying on.
Milady, you're absolutely right. I wasn't as clear as I should have been. So I was simply showing you 137. Perhaps I have referred to 136, but it's 137.
Yeah.
Which is, Milady, you're absolutely right about the earlier step, which is 134.
Yeah.
Now, what you get from 138 is what are relevant considerations. What are relevant considerations? There are two relevant considerations. The first is the size of the business. So if a company has 162 workers and there is a problem with one particular migrant and everything else is fine, then that is a relevant matter for the decision maker to take into account. If, for example, a company also only have 4 workers and 3 out of 4 are said to be occupying non-genuine vacancies, equally that would be relevant. And the second relevant matter is to consider the extent of which the worker is performing the tasks set out in the COS. If the COS sets out 5 tasks and a worker is performing 4 of those 5 tasks, then that would be relevant. But if a worker is not doing any of those things, then it wouldn't. Then that would equally be relevant.
Well, of course, but if the 5th task is the only managerial task, then doing the first 4 would be irrelevant. I mean, everything will depend on the facts.
So the submission is that, yes, the submission is that the decision maker must make an assessment as to the nature of mismatch. So it isn't a mathematical calculation. I accept that.
You told us a moment ago where this comes from.
This is paragraph 138, my lord.
Well, that's right. I just read it once and I've read it twice. I'm just trying to. I mean, this is.
So first part
This
of
is
paragraph.
factors that should have been taken into account in that case.
The submission is that these are factors that the Secretary of State should take into account in every case of this nature. The size of the business and the nature of the discrepancy, the nature of the mismatch. Just one final point. If you look at paragraph 139, and this essentially goes to the next topic about section 31(2)(a). Now, in that case, as I submitted earlier, the Secretary of State gave 2 reasons for revoking the license, C1Z and C1S. There was no challenge to C1S. The challenge was only to C1Z. So a question was, well, what is the point of it? If the Secretary of State had referred lawfully to C1S, what difference it makes that she revoked the license unlawfully by reference to C1Z? Because the decision would have been justified under C1S in any event. Lord Justice Baker said that there is an error as to C1Z. It is flawed and unfair. It is correct that the Secretary of State also concluded that SCL was in breach of a further mandatory ground, but the unfair process leading to the decision as to dishonesty vitiated the overall revocation. The Secretary of State, represented by leading counsel, decided not to invoke Section 31(2)(a) defense in my submission for good reason, where there is a process error leading to an allegation of dishonesty, a finding of dishonesty. And if that decision is flawed and unfair, then the decision ought to be quashed. And you'll see that the decision was quashed. So this is Prestwick.
Thank you.
And these are my submissions on genuine vacancy. Just going into the next topic, which is Section 31(2)(a). So Prestwick is the authority on that. There are two first instance authorities. So instead of sort of taking you to those authorities, may I simply just give you references? I've referred to them in my skeletons. So the first is New Hope Care. Probably I will on reflection take you to those cases.
But just before we leave Prestwick, could you just, for my benefit, we've been looking at SCL in the Prestwick decision.
Yes.
There was a separate appeal by Prestwick itself.
Yes. That wasn't on these grounds.
Sorry?
That appeal had nothing to do with
we
these
don't
grounds.
need that
No.
that appeal for our purposes.
No. That dealt with an entirely different issue.
Right. Okay.
So New Hope Care case is behind tab 7 of the bundle. A license is revoked on a number of grounds set out at paragraph 13, including mandatory and discretionary grounds. The claimant persuades the judge that there was procedural unfairness, and the Secretary of State relied on Section 31(2)(a) to argue that relief should be withheld because there were a number of other issues that were not challenged by the claimant. If you go to page 255, and if you look at paragraph 108, you'll see the submissions that the Secretary of State made. The submissions essentially were that the claimant had not challenged the decision in relation to various matters, and the outcome would be inevitable. The judge concludes that that isn't the appropriate invitation to make for the reasons given at 1110 to 114. And these are, in my submission, good reasons consistent with Prestwick. Paragraph 110, the starting point, and this ought to be the starting point for the court, if you accept my primary submission, that there was a fundamental departure from the standard required by common law. There's a point about process error at paragraph 111. And 113, there is, the judge said, a serious possibility that the license would have been revoked, but highly likely standard is a high hurdle. TJ Trading is behind tab 11. A case about genuine, a case about NXC1Z and C1O. Based on Prestwick, the claimant persuades the judge that the decision was unfair. The Secretary of State invites the judge to withhold relief on grounds of materiality and Section 31(2)(a). And the relevant principles Miss Justice Hill was the judge. She summarizes the relevant principles at page 364. And essentially makes the same point, that there is a process error where there is procedural unfairness. Then even if revocation is a serious possibility, the highly likely standard would not be met. The decision is quashed. So these are the two first instance decision. If you wish to see an authority
I'm very sorry. I was just marvelling at all the authorities that judges now have to read in order to decide these cases. Look at, when you were in this case again, look at page 346. Now, while I was doing that, I failed to get to the passage that you were referring to. Is that 364?
364, 85 onwards.
87.
Yes, 364. Yeah, thank you.
Let's read that.
So paragraph 86 to. Sorry, my apologies. Yeah, so you'll see a heading, materiality, section 31A.
Thank you.
And you'll see a list of relevant principles. And these are the principles that I invite the court to endorse.
And what does process error mean? I mean, because
Fairness.
Arguably that covers everything in judicial review. We're auditing the process of decision making. We're not reviewing the merits of decisions.
So
what does process error mean in this context? Because it can't mean everything is excluded, otherwise 31.2a would have no effect.
Absolutely. So in this context, it means an error that is a departure from the common law duty of fairness. So if there is a failure to comply with the duty of fairness in the context of finding of dishonesty, then that is a sort of error that would lead to quashing of the decision.
Thank you.
Is the expression process error yours, or does
No,
it appear somewhere?
no, it is Lord Justice Baker who used that word in Prestwick in explaining why he was quashing the decision despite the fact that there was another reason. That error was, that point was then sort of picked by other judges.
And is now being used as a statute rather than just guidance.
I don't. Yes, I mean it is essentially a shorthand for saying that if you have made a finding that someone is dishonest with very serious consequences, and if that finding is unfair, then finding should be quashed.
That I can understand. It's when one talks about process error that starts infecting judgments down below, and everyone starts then sort of ignoring 31.2a. And there is also jurisprudence to the effect that we may like or not like 31.2a, but it's our constitutional duty to apply it if it applies.
Yes.
Yeah.
I'm sorry, I'm still in your wake. When you say this comes from Prestwick, could you just identify the paragraph from which the concept of process error arises? Because I don't find it as in a word search.
No, it is. I think so. Prestwick tab 8.
I think it's the first line of para 139.
139. Yes.
And it's a summary of that first sentence.
The process by which the Secretary of State decided. The process was.
Yes, but that just seems to be a perfectly bald statement of a judicial conclusion. I can't see how one gets a sticker that says process error as a concept out of that.
I see the point. I don't advocate for a freestanding process limb or an exception to section 31.2a. You have the point.
All right.
That if there is a finding that is as serious as a finding of dishonesty, with such serious consequences. If the court is persuaded that that finding is unfair and flawed, then the finding should be quashed.
Well, yes, but I mean, let's suppose there's a flawed finding of dishonesty, a thundering list of hopelessness in other respects, which would inevitably have led to the
Same.
license being quashed. The
What
license is going to be quashed.
No matter what. Yeah, I see the point. I mean, that,
331(2)(a).
that is precisely the reason why I took you to Presswick to show the relevant paragraph. So there is a difference between revoking a license with a finding of dishonesty and revoking the license on the ground of an administrative error. If the license
Yes,
is...
but I'm not talking about benign administrative errors and
Okay.
serious
consequences.
and matters of that sort. I'm talking about a situation which exposes a range of serious defalcations, where the license is going to be lost anyhow.
So there is a difference between, in my submission, revoking a license on the ground of dishonesty and revoking the license on the grounds of range of other serious matters that are serious, systemic, but do not involve dishonesty on part of a business.
So are you saying that because a flawed finding of dishonesty has been made, you can't use the statutory carve-out under 312(a)?
No, you do, of course, the statute is binding, but the question is whether it is highly likely that the outcome for the claimant would not have been substantially different. So the outcome, the submission is that the outcome is revocation of license with a finding of dishonesty, as opposed to revocation of finding full stop. So the outcome here is revocation of the license with a finding of dishonesty.
No, but if the finding of dishonesty has been quashed, then it's not an outcome with a finding of dishonesty.
Yes.
It's a corrected outcome with no finding of dishonesty, but a finding of other forms of defalcation.
Absolutely, but
in those circumstances, is your submission, all I need to understand, I'm not agreeing or disagreeing with you, but is your submission that the powers under 312(a) could not be exercised?
They could be exercised.
They could be exercised. Fine, well, then I'm not troubled any longer.
No, Lord, but as you said, then the finding of dishonesty needs to be quashed. And if it's quashed, then there isn't a problem. But our problem, of course, is that the finding of dishonesty isn't quashed. That finding stands.
Yes, well, we're coming on then to the facts of the individual case.
I have referred you in my skeleton to the judgment of this court in Bradbury. Mm-hmm. The court is familiar with the authority. The task of the court isn't to sort of predict what the outcome would be. The task of the court is to decide what the effect of the error has been on the decision-making process. So these are my submissions on law. So I'll now address you briefly on the facts of two appeals in turn. So may I take Jay's supermarket appeal first?
So just before that, which paragraph in Bradbury was it? It's paragraph 151 or something?
This is Bradbury, paragraph 74.
74,
tab 4 of the bundle.
Yeah, don't worry, I know the paragraph, it's just for my note. Sorry to interrupt, thank you.
So Jay's supermarket. Now may I, so if you have the core bundle, yes, so may I take you to page 283 of the core bundle, which is the suspension decision. So this is the first decision that the Secretary of State issued.
Can I just ask, before this suspension decision, this was after the visit on the 2nd of May?
Yes.
And was there any paperwork relating to we're going to come and see you?
There were interviews. There are interview notes.
Yeah, I've seen those.
But they do not assist one way or another.
Didn't they turn up and then the proprietor was not available, and so they then came again a week later?
Yes, but if you wish to see the interview notes, etc., they are in the supplementary bundle.
Yeah.
But I will not take you to them because it's common ground. My learned friend will correct me if I'm wrong. That it wasn't put to the employer and the workers during the interview that there is a suspicion of dishonesty. They were simply asked certain questions.
Yeah, what
They
they're doing.
answered those questions. What they are doing essentially.
I just wondered whether there was a letter before the visit.
No, there wasn't.
So it was arranged on the telephone.
Yes.
Right, thank you.
And it isn't said that the interviews are the answer to my appeal. It is said that, well, this letter is the answer to my appeal.
Yeah.
So page 278. Sorry, my apologies. My apologies. It's page 283. My apologies. So I'll take you to 273 in a minute. Page 283. So this is the letter of 24th of August 2024. We have suspend your license. Why that is so? Paragraph 3, the Secretary of State quotes job description of one of the workers. This is what appears on the certificate of sponsorship. On the next page, the Secretary of State says that we interviewed this person, and he listed these tasks. And there are discrepancies, paragraph 5. And the Secretary of State says that, well, we therefore believe, not that we suspect, as the court said in Balajigari, well, we believe that the role has been created in order to facilitate this person's stay in the UK. So even before the Secretary of State heard anything from the sponsor, she has formed a view that that she believed that this wasn't a genuine vacancy, not a suspicion. And that effectively closed her mind for the reasons that I'll come to. The same point is made at page 285 about the other worker. Paragraph 13, job description is set out. Paragraph 14, in the interview, the worker said X. And paragraph 18, we believe that this isn't a genuine vacancy. So two points, my lord, that arise from this letter. First, there is no allegation of dishonesty in this letter, either express or implied. There's no clear indication, or indeed any indication, that the Secretary of State suspects that the business is dishonest.
So what about paragraph 18 and its predecessor?
Yeah.
Paragraph 8.
Yeah. So the role has been created in order to facilitate.
No, it doesn't constitute a genuine vacancy.
So you,
As you told us earlier on,
yeah.
aspersions about genuineness
Yeah.
are a form of allegation of dishonesty.
Yeah. So, my lord, the point is that, well, when the Secretary of State says it isn't a genuine vacancy, that means dishonesty, and that means that this is the
Yes,
opportunity.
I mean, I'm trying to work out whether your submission at this point is that they've decided we're dishonest before asking our opinion about that,
Yes.
or they're not accusing us of dishonesty, because it can't be both. And I think you've said both quite recently.
Yes. Now, my submission, of course, I do make both points in the alternative.
Well, no, they don't seem to be in the alternative. They seem to be contradictory. I mean,
There is.
from where I sit, paragraph 18 looks as if it is an assertion that the business has not been dealing in a straightforward manner with the system which it has been allowed to participate in. Not whether that's right or wrong, but simply that that's the assertion that is being made to your client about that. I mean,
And my lord,
is that something that you wish to challenge? Because I may be wrong.
Yes. So, my lord, before you accept or reject this submission, I do ask you, my lord, to just bear in mind what was said in Prestwick. In Prestwick, the suspension letter made the same point. In the suspension letter, the Secretary of State said that, well, this is not a genuine vacancy. This isn't a genuine vacancy. This is your opportunity to explain why it isn't. But the court said that that isn't enough. It's not enough to simply say that there isn't a genuine vacancy. You got to put the allegation of dishonesty expressly to the business so that they...
Your submission, which we'll have to consider, is that paragraphs, I think it's 8, but certainly 18 in respect of the two individuals, is not
enough, yes.
It is not squarely putting
yes. Yes.
This is
an allegation.
Straightforward.
Yes.
So, Mr. Mallet, you say, do you, that 8 and 18 ought to say, rather than we believe, we have grounds for suspecting, or we have a suspicion that the role of shopkeeper does not constitute a genuine vacancy within your business, and accordingly, your business or you are acting dishonestly. And they should have used the word dishonestly.
Yes.
That is the sum total of what you're saying.
Yes.
Okay.
Yes. You're now saying they had to use the word dishonest. I thought you'd moved away from that under some.
No, if I had, then I apologise because.
Okay, but it's useful to be clear.
Yes.
I mean, you say that for the process to work fairly, the word dishonest has to be used.
Yes, and I'm grateful, and I do say that that is the submission that is endorsed, supported by Prestwick. See paragraph 134 and 137.
And I write that you also say, that's why I just wanted to clarify, that we believe is not enough or is wrong.
Well,
it should be we have
suspicion.
Grounds for suspicion, or we suspect.
Yes, but as my Lord Justice Peter Jackson just observed that the 2 points are perhaps contradictory, and
yes, because I mean, on the one hand, you might be asserting that there have been prejudgment.
I see, yeah.
And on the other hand, you appear to be asserting that this doesn't constitute a sufficient warning.
So it's essentially the later point that I make, the second point. It's just that there could be a point that the Secretary of State sort of prejudged the application, but I need not to push on that point.
And so, although I thought we'd understood that a formula by which the Secretary of State shared her suspicions was sufficient for you, I'm now clear that it's not. The Secretary of State has to say in terms that you are dishonest.
Well,
That's your position.
yes, but I mean, instead of dishonest, the Secretary of State can say that you've been deceitful. I mean, as long as that allegation is put.
So it's although the guidance speaks of circumstances, your submission is that that the decision actually has to deal with mental state.
The decision must state with yes, because
it must deal with mental state, and it must do so by using one of a very small number of thesaurus words which have the same meaning as dishonest.
Yes, because there is an element of mens rea here. I mean, a deliberate action is on part of a business is needed. So, I mean, another way would be to put the business that, well, you are deliberately abusing the system. So that is the point that I do make. Secondly, you'll see how the Secretary of State has framed the point at paragraphs 8 and 18. The role has been created. But when I showed you the policy, you'll recall that another word appeared before the word created. The role has been primarily created in order to facilitate a person's stay.
So this goes further than that.
This goes further, yes. So that is the second point that I make. That even if
that
this
would be a point against you in this context, because they've gone further in casting criticism on your client's actions than they needed to do in order to satisfy the guidance.
I see the point. My submission is that the effect of the word primarily essentially is that the decision maker must decide what is sort of primary purpose of this employment.
I'll just give you the opportunity to do this. You appreciate from some of my questions that it seems that this is becoming awfully technical.
Yes.
That the court fully understands the essentials of procedural fairness and the duty to warn, the duty thereafter to give reasons. But in this case, the Secretary of State has visited, has carried out some inquiries, and has reached the conclusion that she's seen individuals who are meant to be acting in a managerial capacity, in fact, just stacking shelves. Now, that's the big picture.
Yes.
Are we not getting some way away from that? Because that's what this letter communicates.
No, yes. But that could be the result of the person covering for a colleague on that particular day, not necessarily dishonesty.
Yes, but we're coming on to the point my Lord made earlier on. Of course, managers sometimes have to stock shelves if businesses are to stay open, but that's not meant to be what they do. They're meant to show evidence of managerial activity, and that's what the Secretary of State was concerned was missing.
I get that. So ultimately, this point comes down to whether you're satisfied that paragraphs 8 and 18 are sufficient to meet the clear indication.
Well, I think I'm sorry to press you on this point, but I think we've been around that.
No, thank you. So there are a number of other points made in this letter that are not relevant. Now, following
And
this,
we find the process at 46. Next steps. Give you the opportunity to explain the above issues, etc.
Yeah. So same paragraph that is used in Prestwick copy. Now, following this letter, the Secretary of State revoked the license because she received no submissions, no evidence from the business. The business wrote back saying that, well, we did not receive the suspension decision on time. The Secretary of State agrees to reconsider the matter. So it's really the reconsider decision that we need to focus on. But before the reconsider decision was taken, the business sends evidence to the Secretary of State. The evidence that Lord Justice Peter Jackson, you observed a few minutes ago, is needed to show that these are genuine vacancies. These are actually managers as opposed to people who are stacking shelves. So can I just show you that evidence very quickly before I show you the revocation decision? So if you have the supplementary bundle, may I ask you respectfully to go to page 63 of the supplementary bundle. So this is the evidence that the Secretary of State in my submission completely ignored when she made the revocation decision. Failed to take that into account. So page 63. I'll take you to these three documents very quickly, but I do ask you, my lords, to read them in full in due course. So 63 is the witness statement by Mr. Ramachandran. He explains, when you read that statement in due course, see page 66, as to how he recruited these individuals, what was the commercial need for these roles, and what sort of duties they are performing. And then 66, he says that on the day of the visit, this Naveen was covering for an absent staff member. And when the officer asked him as to what he was doing, well, he essentially told the officer what he was doing on that day. And then he explains, provides an explanation as to Manoj, and explains how they were recruited, what was the commercial need, and so on and so forth. Page 70 of the bundle is the witness statement of Naveen. It's a detailed statement. He explains why he was recruited, why the vacancy was genuine. He explains his qualifications, sets out a long list of products that he deals with. And then page 74 explains his key responsibilities, gives evidence that he is responsible for organization of the store operations. He assigns tasks to the staff. This is paragraph 19. Paragraph 9, he supervises them. He handles complaints. He plans and oversees promotional events. And he ensures that health and safety regulations are met. So paragraph 9. And then he provides a further explanation as to what he does. And then what happened on the day that he had to clean up a bottle that a customer had broken, as it took some time for the other staff to attend. So in other words, in short, he's saying, I'm the manager. This is what I do. But on a day I was covering. Manoj, and then he explains what happened in the interview and etc. So Manoj's witness statement, page 77, he provides an explanation, again explains that his role, how he was recruited, how he was interviewed, what skills he has, what happened on the day, and so on and so forth. So in short, of course, there isn't enough time for me to take you through these statements in full. But in short, they are saying that these are genuine vacancies for these reasons. And the question is whether, not whether these reasons are good reasons, but whether the Secretary of State considered them. The revocation decision, which is under challenge, is page 237 of the bundle.
Oh, the supplementary bundle.
Sorry, the core bundle, my apologies, core bundle.
No worries.
You'll see that this letter essentially copies from the earlier suspension decision. And concludes at page 240. Look at paragraph 18, 19, 20, 21.
I'm sorry, could you, it's core bundle page?
Core bundle page 237.
237, thank you.
And the real reasons, the key reasons are at paragraphs 18 to 21. So 18, the Secretary of State says that, well, I would question how often this person is required to cover for other staff. If he is covering regularly, then there could be a concern. Screenshots and pictures are not enough, and we are dissatisfied that your client has demonstrated that he is performing the duties. And then if you look at paragraphs 33 to 36, paragraph 33, you have failed to provide, as part of representations, any evidence of jobs undertaken. Paragraph 33, page 242. There was evidence, the witness statement evidence.
Well, there's a paragraph which says what his duties were, that it was unsubstantiated by any actual evidence of doing them.
Well,
I mean, is the Secretary of State required to act on the say-so of individuals?
No, but a person makes a statement. The decision maker can accept that statement. The decision maker can reject that statement. But the decision maker must consider it. The Secretary of State did not say that I have considered your witness statement, but I do not believe you because your evidence is not corroborated by other documentary evidence. She's not saying that.
Well, what she's saying is, you've given me quite a lot of stuff, but none of it relates to the issue with which I'm concerned. I mean, there are pictures in the bundle of shelves.
So, yep, I agree. So pictures do not assist at all. And I do not rely on pictures. Of course, pictures do not assist. I rely exclusively on 3 witness statements that I've shown you, which the Secretary of State has not considered. My learned friend does not submit that the Secretary of State has considered these witness statements.
When did the witness statements and the screenshots of the WhatsApps and the pictures go to the Secretary of State?
At the pre-action stage, before the reconsider decision is taken. So the first decision is taken, the license is revoked. The applicant says to the Secretary of State that, well, I did not receive the original decision. This is my evidence. Please consider it.
Do we have the letter that shows, that sends the materials? That might help.
Yes.
I think, funny enough, it's in the supplementary.
Yes, I think it's in supplementary bundle, page 60. Yes, page 62. I'll just find the page. Of course. Page 253 of the core bundle. I'm very grateful to Milan.
Core bundle?
Yes.
Right, thank you.
So this is the letter of 26th of October 2024. And the witness statements, if you look at page 271.
Hold on a second. 253.
It's 253.
Right, so that's 26th of October. As you
Yes.
Right, so there's a pre-action letter of the 26th of October.
And if you look at the last page of that letter, it sets out the documents that are attached. Page 271.
Thank you.
And there you'll find the 3 witness statements.
271.
Yes.
Right, so it all went in one go.
Yes. The Secretary of
So where we be looking at the commentary in which things are said about WhatsApps not being affiliated to the individual, photographs not being of much help.
Yes.
That is all in response to this letter, which included all of the documents. And
Yes.
were to infer, it's not what the judge inferred, but the judge had to infer, did he, that the Secretary of State simply didn't give any consideration to the witness statements.
Well, that is the submission.
That's the submission.
Yes.
Okay.
That submission in my submission is reinforced by 3 further points. The first, my lord, is that the Secretary of State, there was a witness statement given on behalf of the Secretary of State in these proceedings. The Secretary of State could have said, the author of the statement could have said that, well, I considered these witness statements.
But isn't that what is said at paragraph 4 on page 237 in the letter of the 12th of November 2024? Following receipt of the PAP letter,
Yeah.
we have considered the representations received with the PAP letter.
Yes. So there is.
But what can that refer to other than the things we've seen in that list,
Well,
which included the statements?
Yes. So there is a difference in my submission between representation and evidence in support of those representations. Okay. So these are the representations in the pre-action letter where over many pages the business is making points about law and procedural fairness. Those submissions are supported by evidence in the form of witness statements.
I see.
And the submission is that those witness statements were not considered. There is no evidence by the decision maker that those witness statements were considered. The second point, my lord, is, and this is the point that I made below, the Secretary of State does not plead, and Miller and Friend does not say, that these witness statements were considered by the decision maker. If Miller and Friend says that on instructions that the decision maker considered these witness statements, I will withdraw the point. There is no evidence that the decision maker considered these statements. Miller and Friend isn't saying that these witness statements were considered. And the inevitable conclusion is that these witness statements were not considered. The alternative submission, if these witness statements were considered, then the decision is simply irrational. There is no engagement with the content of the witness statements. You will, I'm sure, read those witness statements in full in due course. Well, how they were recruited, what was the commercial need for these vacancies? What is it that they do on a day-to-day basis? What happened on that particular day is all explained in those witness statements, which there isn't any engagement with the witness statement, and therefore the decision is irrational. Lord, you have then the judge's judgment in Jay's supermarket case at page 64 of the bundle. Starts at page 60. Page 65 of the bundle. The relevant paragraph that is the key paragraph is.
I'm sorry, could I just go back? On page 240 of the core bundle, which is the reconsideration letter,
Yes.
we have at paragraph 17 under the heading reconsideration.
Yes.
Within the representations, it states, and then you have an italicized paragraph.
Yes.
And I'm just thinking that it bears a very, very clear resemblance to a paragraph which is at page 66 of the supplementary bundle, which is within the statement of the person who owns the business, Mr. Ramachandran. And there's a paragraph, the second paragraph starts on the day of the visit. That is quoting is that not something that is being said by the maker of the statement on the day of the visit? This particular person, a retail manager, was covering for an absent member of staff, etc.
Yes. Lady, I will find the relevant paragraph. I think what is quoted is taken from a paragraph in the pre-action letter in the representations.
Okay.
But I do not.
But it is almost identical to that paragraph, which is on page 66, which is within the statement.
It's not almost identical.
I'm sorry.
It's identical.
Yes.
Page 66.
Well, it's.
This is from the proprietor's own witness statement. It has been lifted.
Yes.
But I think it's identical.
Yeah. And so I'm a little confused because I think that there is reference to the evidence within the letter.
Yeah. Lady,
That's what I'm saying.
Yes. Lady, I understand the concern, but
Yeah.
may I just come back on
Yes.
on that, and I'll make sure that I answer that. Now, well, I have sort of 15 minutes to conclude my submissions. Now,
You have, no, we're not going to clock watch, but we've been engaging with you quite substantially, so
Yeah.
take the time that you need to make your submissions.
I'm very grateful. So in that case, may I just take you to the key paragraphs in the judge's judgment. So if you first go to page 94 of the core bundle, paragraph 71, the judge held that the paragraph, my Lord, that Lord Justice Peter Jackson picked from the decision, paragraph 18 and 8, was the answer to the point about procedural fairness. The judge says that there is a successive step in the chain of causation.
So which paragraph?
Paragraph 71. So this is really the key paragraph where the judge rejects the Balajigari point. I have made my submissions. If you accept my submission, you will disagree with the judge. If you reject my submissions, you will agree with the judge. So this is the point about fairness. Now, may I just take you then to paragraph 63. So 71 is about fairness. 63 is about rationality and reasoning. And the judge says that the Secretary of State, it was open to the Secretary of State to consider that there was no real correlation between that description and the COS. But the Secretary of State did not say that there was no real correlation. You have seen the decision. The Secretary of State said that there were discrepancies.
I wasn't quite clear what the difference between those concepts were.
No real correlation means that, well, there is no match at all. Discrepancy.
It's just that it's a use of words, isn't it? I mean, basically they're saying the individual is not doing the job for which the certificate was designed.
Well, yes, I see the point.
I'm just not sure that there's any real substance in the difference in wording.
No, if the job description requires a person to undertake 5 tasks, and if he is undertaking 4 out of 5 tasks, it cannot be said that there is no real correlation. It can be said that there is a discrepancy.
All right, that's as far as it goes.
That's the point. And then I do submit that this conclusion is wrong. The conclusion that there is no real correlation is an irrational, inadequately reasoned conclusion because the relevant evidence wasn't taken into account. There was no engagement with the witness statements.
Is there within the documentation that was provided to the Secretary of State any corroborative evidence of the individuals concerned, either of the 2 individuals actually performing tasks of a managerial sort?
No.
No. It's because there's a large amount of information. That's what I'd understood.
No. Yes, but my Lord, if the point is troubling you, I do ask you to consider what sort of corroborative evidence a shopkeeper can produce to explain the job that he's doing, apart from explaining what he does. So a shopkeeper would say that, well, this is what I do. It's difficult in my submission to contemplate the existence of sort of corroborative evidence. I mean, if you're a barrister, for example, you can produce your advices and skeleton argument. But if you're a shopkeeper, there's nothing more that you can do apart from making a statement saying this is what you do.
personal injury litigation, people produce diaries of the day and the night of, etc.
Okay, can I then perhaps put the point in this way that, well, the Secretary...
It's not on the defendant, I know that.
No, I mean, the Secretary of State isn't saying that, well, I expected you to produce this and you haven't produced that. So that isn't the Secretary of State's point. So 63 is about rationality reasoning.
63.
Sorry, 63, yes, paragraph 63 of the judge's judgment. And then paragraph 58 is taking you, sorry, not 58, sorry, paragraph 68, my apologies.
Yes.
So 68 is about the existence of there being no reference to the witness statement. The judge said that it's regrettable. An express reference would have made it immediately clear that they were considered. And the judge takes the view that they were indeed considered. And subject to the point that Milady raised, I do make the points that I've made earlier. The Secretary of State, there's no engagement with the witness statements, no evidence, no pleadings that they were considered. And that is in my submission, the answer. Now, if you, so this really is ground one. Now, if you accept ground one, in my submission, ground two succeeds. And the judge declined to grant relief essentially on the basis of the judge's finding that there was no unfairness, the decision was rational. But if it wasn't, then the second ground becomes academic. But if you're not with me on ground one, you then need to consider ground two, which is where the judge said that, well, paragraph 111 and 112, where the judge said that, well, forget about NX C1Z. The decision is justified under NX C1S. The judge says that it's justified under C1S, essentially because of the earlier findings that there is no real correlation between the job description and the role that the applicant was performing. So if you're not with me on first ground, the alternative, the second ground is that it wasn't appropriate for the judge to withhold relief on that basis. The Secretary of State never, at no point, relied on NX C1S. In the suspension decision, she isn't saying that there is a suspected breach, this is your opportunity to make submissions. She did not rely on it in the decision, in the revocation decision either. There is no evidence from the Secretary of State as to how she makes decisions under NX C1S. The error here was a fundamental error, a departure from common law duty of fairness. And the judge should have quashed the decision under NX C1Z as opposed to upholding it under C1S for all the reasons that I've given. So this is J Supermarket.
Well, I wonder whether I'm very anxious that that your clients, your other clients, have the same opportunity to have us consider the arguments on the facts of their case. Would it be convenient if we rose now and asked you how long you think you would like to take in order to run through those arguments?
Well, 15 minutes, because
the very amount of time. Would it be convenient if we stopped now and started again at 1:45
Yes.
Two. Very well. That's what we do.
For around 8